Today we have decided to speak on the various civil suits under the Code of Civil Procedure, as well as other statutes or legislations which providing providing provision for filing suits and to obtain substantive. All of you know that here your right title in interest, your right title in interest of a person is determined by a substantive law. Many substantive law like Transfer of Property Act, Hindu Succession Act, trademark, patent, other intellectual property, they contain provision for substantive suits, isn't it? Then the Code of Civil Procedure, though, is a procedural law which tells you where the proceedings are required to be filed, also makes provision for certain suits. Many suits, in fact, not certain suits. So we learned under Section 9 of the Code of Civil Procedure that tells you the jurisdiction of the civil code, Section 9, isn't it? So I won't be reading the section. I'm just giving you the scope of the section. You, as a young lawyer and a young student, will be in a position to pinpoint. Section 9 tells you the jurisdiction of civil code, which is very wide. Civil suits of a civil nature, all suits which are of a civil nature, such as a contractual relationship, determination of a property right, determination of civil rights, determination of family rights, determination of a mortgage rights, determination of trustee relationship. These are all matters falling within the ambit of the Section 9 of the Code of Civil Procedure, determining a title of the property, right title interest of a property. You go to the civil code under Section 9. Of course, if there are special acts providing that here, certain suits are required to be filed in special legislation, such as rent control legislation provides all suits between landlord and tenant to be tried in the Court of Small Causes Court in Bombay, and Civil Just Senior Division, Junior Division elsewhere, and Provincial Small Cause Court Cat. Then Cooperative Society Act, Section 91 specified that all disputes between a member and a society are required to be tried in a cooperative court under Section 91 of the Societies Act. These are special acts. Now, similarly, Family Court Act, Section 7 provide that here all suits relating to family, divorce, custody, guardianship should be filed in the family code. Earlier it was in CPC. CPC, it was the provision. Now the CPC also contain the provision, but wherever there is no family code, you go in the family code. Now let us first, Section 9 ka 9 ho gaya, you determine the jurisdiction in the Code of Civil Procedure Code. Then the next step is Section 15 of the Code of Civil Procedure tells you every suit should be filed in the court of lowest jurisdiction competent to try. So we gave you the examples of various civil suits under the Bombay Civil Courts Act, under the Presidency Small Cause Court Act, Provincial Small Cause Court Act, Cooperative Court Societies Act, and various other legislation. It's being a subject falling within the ambit of the concurrent list. State, every state makes a law relating to the state. There are in Calcutta and Bihar, we have municipal courts, isn't it? There are Fauzdari Adalat Paile the, isn't there? Was abolished. There are various names you can give. I am now confining here to especially the state of Maharashtra, particularly the city of Bombay. In the Bombay city, the lowest court of a civil nature is at the moment is the Court of Small Causes Court, where general civil nature suits it decides up to 25,000. But special suits between landlord and tenant, unlimited jurisdiction. Special suits between licensee, licensor, unlimited jurisdiction, isn't it? But summary suits and regular suits will be up to 25,000. The city civil court jurisdiction is in civil matters. In civil matters falling within the ambit of Section 9 will be from up to 10 crores as per the Valuation Act, which has been now amended by the state of Maharashtra. In that, about 10 crore will go to the Bombay High Court original site. So in the original suit, the Bombay High Court acquires the jurisdiction I mentioned to you by virtue of the provisions of clause 12 of the latest patent, which is a latest patent ke andar the three high courts were established. All of you know that here, Calcutta, Madras, and Bombay in the year 1861. It's 61. So these high courts have original jurisdiction to entertain the suits. Normally, other high courts are courts of appeal. They are courts of revision, courts of appeal under Section 96 First Appeal, courts of revision under 115 of the Code of Civil Procedure, where the interlocutory orders, where substantive rights are affected, are revisable. Now, similarly, the Supreme Court of India is also court of original jurisdiction under Article 131 of the Constitution. Suits between two states, suits between the central government, state government, suits between the union territories with regard to territorial dispute, with challenging any legislation of the parliament or state government, they directly file under Article 131 of the Constitution of India. Likewise, we are filing directly suits in the High Court, Bombay, Calcutta, and Madras by virtue of clause 12 of the latest patent. So all these suits in the city of Bombay, where the valuation of the property is about 10 crore, they come to the Bombay High Court. Now, let us understand from the serially the under section 16 of the Code of Civil Procedure. This speaks of filing of civil suits subject to the pecuniary limits and limitation. Now, if you open your CPC, if you're having, just cursorily go through section 16A. Section 16A, I will just explain what kind of a nature of suits they come before the court. The suits are for recovery of immovable property, suit for recovery of movable properties. The suits are for partition, the suit for administration, the suit for foreclosure, the suit for mortgages. There are various suits I'll explain to you. Now, when you open section 16 of the Code of Civil Procedure, especially those who are students, they will come to know. Now, section 16 says that here, suit for recovery of immovable property with or without rent and profits. It says, subject to the pecuniary and other limitation prescribed by law, the suit shall be filed in a court where the property is situated. Number one, what are the suits for recovery of property which you are required to file within the local limits of the jurisdiction of a court where the property is situated? You cannot go. If the property is situated in Mumbai, you cannot. You defendant may be residing in Calcutta, Madras. You cannot file a suit for against the defendant in Calcutta, Madras, isn't it? Recovery of the property, jahan pe property is situated. If the property is situated in, suppose, Pune, you have to file in Pune District Court or a small causes court, provincial, or situated in wherever place it is to be well. Section 16 language says that, number one, the category of the suit, recovery of immovable property with or without rent or profit. Now, this particular suit suggests that here, the plaintiff is filing a suit for recovery of immovable property. If a suit is being filed for recovery of immovable property in the city of Bombay, for example, it is a trespass suit for a declaration. You are seeking a declaration under section 34 of the Specific Relief Act. For a declaration that the defendant is a ranked trespasser, does not have right title interest. He should be directed to pay mean profits. Mean profits are the profits which he is in occupation from the date of the occupation liable to pay. Now, such a suit in the city of Bombay will be filed in the city civil court if the valuation is up to 10 crores. And it will be filed in the Bombay High Court original site if the valuation is about 10 crore. Now, such suits cannot come to the small causes court or cooperative court, because small causes court, there is a bar under section 19 of the Presidency Small Cause Court Act. Title suits cannot be decided by the small cause court. Please note that here. So a suit of this nature, for example, I gave you under section 16A, for recovery of immovable property from a trespasser will be filed in a civil court. Normally in a civil court, section 9 jurisdiction will be invoked. In a city of Bombay, for the purpose of High Court, a clause 12 of the latest patent read with section 9 CPC will be invoked. Okay, that is a trespass. Now, and a suit, it also says recovery of immovable. Suppose if it's a suit for recovery of a tenanted property by the landlord from a tenant, you cannot go to a civil court. There's a bar under section 33 of the Maharashtra Rent Control Act. 33 says that here, section 33, notwithstanding anything contained elsewhere in this act, the Court of Small Causes Court, if for the city of Bombay, shall have exclusive jurisdiction to try all suit between landlord and tenant. And similarly, the Court of Civil Just Senior Division, Junior Division shall have jurisdiction to entertain and try the suit between landlord and tenant. That is under the Maharashtra Rent Control Act of 1999. Here, when a suit is now under the Maharashtra Rent Control Act, there are suits for recovery of the property is filed by the landlord under two provisions. One is under section 15, another section 16. Section 15 suits deal with, they are called known as relief against forfeiture. Forfeiture is defined under section 111G of the Transfer of Property Act. Forfeiture means a tenant committing breaches in the payment of rent. If he is not able to pay rent within the time stipulated by the law, so suit for infringement, suit for recovery of rent will be filed under section 15 of the Maharashtra Rent Control Act by giving 90 days notice. Please note that section 15 mandates the landlord must give 90 days notice, a notice contemplated under section 106 of the Transfer of Property Act, that is called termination notice or a quit notice. Without giving this 90 days notice, you cannot recover, you cannot evict a tenant from the premises on the ground of arrears of rent. That is called a forfeiture clause. In every lease, you will find here, if a lessee has violated the terms of the lease, not paid the amount of the lease within the period so and so, he incurs the disqualification of forfeiture, which is eviction under the provisions of the lease. So such a provision is contained under section 15 of the Maharashtra Rent Control Act. Now, if within 90 days, if he doesn't pay the money, the landlord filed the suit in the Court of Small Causes Court, then the court will ask him to deposit rent with 15% interest and with a direction to pay the money periodically. If he doesn't commit any mistake, the landlord's suit for eviction will be dismissed, and he will only get arrears of rent and mean profit and the interest rate. But if the tenant commits any mistake, if any breaches are committed as per the order of the court, he will not only be required to pay the rent and mean profit, he will be evicted from the premises. That is section 15 story. Now, the second category of the suit which are filed by the landlord in the Court of Small Cause Court in Bombay are pursuant to section 16 of the Maharashtra Rent Control Act. Under section 16, there are grounds to be mentioned. Ground A, B, C, D, E, F, G, H, I, J till N tak hai. These are grounds. For example, tenants have committed breaches of the terms of the lease, 16(1)(a). B, he has rendered himself liable for commission of an immovable property. C is a nuisance. D, he has committed immoral purpose. E has committed subletting. Section 16(1)(g), a bona fide requirement. Section 16(e), that is a ground of subletting. The various grounds are there. If the tenant has committed breaches, a suit of eviction can be filed against the landlord in the Court of Small Causes Court for recovery of the possession and also demand mean profits. Mean profits become payable from the date of the filing of the suit or termination notice. Now, remember that here, for the purpose of section 15, termination notice is mandatory and for 90 days time. Whereas for filing a suit under section 16 on various grounds of eviction like bona fide requirement and subletting and non-user, the landlord is not required to strictly give notice under section 106 of the Transfer of Property Act. This has been held by the Supreme Court in the case of Dhanpal Chettiar versus Yashodama Ammal's case, that is 1979 Supreme Court, page number 1745. This judgment is a landmark judgment given by 11 judges of the Supreme Court. All of you should know that, those who are interested in practicing in property law. Please note that. So that is the nature of suits. Second category of the suit for recovery of the property in the small cause court. The third category, so they are known as a RAE suit and RAENR suit. RAE mean Rent Act Eviction suit, and RAENR mean Rent Act Eviction and recovery of rent, recovery of the same. Then the third category of suit are called non-rent act suits, which are filed under Transfer of Property Act, a termination of a lease, or a premises are given to a banking company, a school, a company having a share capital of more than 1 crore, they are not protected. A premises may be an open plot of land. They are not protected under the rent control legislation now. With the passing of the Act of 1999, with effect from March 2020, they are not protected. So the requirement, suppose there may be a lease between the landlord as a lessor and the bank as a lessee for 15 years. Upon the expiration of the lease of 15 years, the lessee cannot exercise the right to renew the lease because protection is taken away under Section 3 of the Maharashtra Rent Control Act. Similarly, open plot of land protection is taken away from the definition of Section 7(9) of the Maharashtra Rent Control Act. So what is the requirement? They are called non-rent act suits or suits under the provisions of Transfer of Property Act. The requirement is that here, these suits are filed not under the Maharashtra Rent Control Act. They are filed under Section 41 of the Presidency Small Cause Court Act. The category of the suit is known as TENR suit or TE suit, tenant eviction suit. So the only requirement is that here, the landlord, the lessor, is required to give a termination notice under Section 106 of the Transfer of Property Act, which postulates 15 days notice. Or if the lease deed postulate that notice is required to be given of 3 months or 6 months, you have to give that accordingly. But if the lease is for a fixed period for 15 years, 20 years, and determined by efflux of time under 111 of the Transfer of Property Act, termination notice is not required. There are series of Supreme Court judgment in that point. Please note that here, suit can be filed straight away without giving a notice to it. So that is called a TE suit under Section 41 of the Presidency Small Cause Court Act, where the protection is not available to a tenant under the Rent Act. I mean, there may be relationship of landlord and tenant, but they are not statutory tenant, nor they are contractual tenant. Bombay Rent Act, Maharashtra Rent Control Act, or rent control legislation in India, they are governed, their tenancy is governed, their tenancy is called statutory tenancy or a contractual tenancy. Please note that here. Whereas a tenancy under the Transfer of Property Act called the tenancy created by virtue of a lease or a contract under the Transfer of Property Act. That can be determined under 111 of the Transfer of Property Act, determination how the lease is determined. So they become non-rent. In Bombay city, the Bombay Port Trust is the biggest landlord. They have let out various godowns to everybody, isn't it? Now Rent Act is not applicable to them. Now what kind of a suit they are required to file against their tenants? The suit under Section 41 of the Presidency Small Cause Court. Yeah, the suit is called under Section 41E of the Act here. Please note that here. TE suit or TNR suit. So they are called. Similarly, you may be having a paying guest in respect of a commercial premises. Now, residential premises leave and license, you can go before the competent authority under Section 24 of the Maharashtra Rent Control Act. You can get him evicted if he doesn't vacate after the expiration of your tenancy agreement, the leave and license agreement after 11 months or whatever time duration. But in respect of a commercial premises in the city of Bombay, if you have taken the premises for a period of, say, running a hotel, running an office, it's a commercial premises, they are not covered under the Section 24. Then the suit will be filed under Section 41 of the Presidency Small Cause Court Act. Again, a suit in the nature of a TE suit or it's called LE suit, licensee eviction suit. Their suits are LE suits, licensee eviction suit, which you are required to file. Similarly, you have a paying guest at your home. A paying guest, you kept it for a period of 6 months, 3 months, students from the law college or any other college, or some employee by reason of exigencies of employment, he came to city of Mumbai, Calcutta, Madras. He is not vacating the premises. You give a notice for termination. That suits, that provision for leave and license is Section 52 of the Easement Act. All of you know that what is a license is defined there as a privilege. License is not a right, whereas lease is a legal right. A person has a lessee has a inalienable right, vested right in the property, whereas a lessee has no, whereas a licensee has no legal right. He is only it is only a privilege he is enjoying, which privilege can be revoked by the grantor, that is the license, or any time. So you have seen many cases of leave and license agreement in the city of Mumbai, on the ground that here, the it may be for 11 months, it may be for 2 years, 5 years, 6 years. So residential category, non-resident category. Residential category suits, I told you, they will go before the competent authority, which is situated in Bandra at Mahada complex on the 4th floor. Please note that their authority, it is not a court, but it is a tribunal. They are supposed to dispose it of within 6 months, but never happens. But whereas the suits for recovery of immovable property under license, leave and license, you will have to file a suit in the court of Small Cause Court, Bombay. If the property is situated in Colaba to Bandra, Colaba to Mahim, it will be in the town, Dhobitala suit. If the property is situated in Bandra to the Daisar, you will go to Bandra Small Causes Court under Section 41 of the Presidency Small Cause Court Act. Licensees are gratuitous licensees. Gratuitous mean free of consideration. You may take up the plea that I allowed my friend to stay free of charge. I allowed my brother to stay free of charge. The father may say, my son was allowed to stay along with his wife as a gratuitous licensee without contributing. I do not want them. They are troubling me. I want them to be evicted. So apart from the senior citizens tribunal, and you can also go to the Small Cause Court, Bombay, if you are not a senior citizen, under Section 41 for eviction. So these are the nature of suits under Section 16. Then the third category of suit refers to under Section 16, suit for partition of immovable property. See, Section 16b describe partition of immovable property. Now, what is a partition? Suit is given both under the Transfer of Property Act as well as under the Partition Act of what is the act number? Just see. Partition Act. When you see the Partition Act, that contemplate two types of suits: partition suit and suit for administration. If your forefather, grandfather had died here, they died. Your big brother, your uncle is not vacating the premises and not giving your share, not your share, then you have a Partition Act of 1893. Please make a note of it. A Partition Act of 1893, as well as you can file a partition suit, and some of the properties you may recognize, you may be in a position to give description. And some properties of your grandfather who was a big businessman, some properties may be in Calcutta, Madras, and Bombay. Your prayer will be that this honorable court be pleased to administer the property of the grandfather, which are in the hands of the defendant, and thereafter partition the same and giving the plaintiff share. Now, such a suit, suppose in the city of Bombay, you will file in the original side of the Bombay High Court. So you normally in a suit where the immovable property, some of the properties are situated in Mumbai, Calcutta, Madras, Bombay, you will have to obtain leave of the court under clause 12. There is a clause 12 of the latest patent that the court normally grants it. You have to mention, my lord, some of the properties are situated in city of Mumbai, some are in Calcutta, Madras. My grandfather was a businessman. He left behind my father many properties. My big brother has been controlling the property, and we are 5 sisters and 3-4 brothers, and our shares are being deprived. In such a scenario, you will take up the plea that your big brother is acting in as a trustee in a fiduciary capacity. He is bound and liable to partition the property and also give accounts for it here. So a suit for administration coupled with partition would lie if it is Bombay city, the property more than 10 crores, City High Court, Bombay. If it is City Civil Court, you file in Bombay City Civil Court on a leave to be taken under Section 20 of the Code of Civil Procedure. Please note that there is a leave granted where the properties are situated, defendants are residing elsewhere. Section 20 of the CPC speaks of leave. If you closely go through that here, leave of the court. See, clause B of section 20 say that, or any defendant where there are more than one at the time of the commencement of the suit actually voluntarily reside or carries on business personally, provided that such a case either leave of the court be given. So if you take the leave of the court, you can file a suit. Similarly, under the court of in the Presidency Small Cause Court Act, there is a provision under section 18. If the defendants are residing in various jurisdiction, leave of the court can be taken. This is a special act here. So that is the second class of suits, a third class of suits here. That is partition of immovable property. I also added along with the partition the administration suit. Okay, administration suit mean the properties which you are not able to determine. The court will appoint a court receiver. Court will appoint a commissioner to find out. You will give a direction to the defendant. Please disclose on affidavit what are the properties in your hand, so that the court will be in a position to administer, adjudicate, and also partition the same depending upon the rights of the parties. If they are Hindus, equal rights. If it is they are Muslims, the boy will take double, the girl will take lesser than that. So depending upon the various rights under the Succession Act. Okay, that you understood. Now the next category of the suit is for foreclosure suits. Foreclosure, sale or redemption in the case of mortgages, charges upon immovable property. Now, under the Transfer of Property Act, you have learned section 58 onward, 59, 60, 70, the various mortgages, English mortgage, there is a simple mortgage, there is a mortgage by title deed, usufructuary marriage, mortgages of immovable property I'm talking of. Now, for recovery of those properties, suppose I have mortgaged my property to you for a period of 10 years. I was needing the property. I was needing amount for maybe a construction loan, maybe a marriage in my family, maybe A reason, B reason. I did not have sufficient money. I came to you and mortgaged my property. Isn't it? After mortgaging the property, maybe for about 1 crore rupees for a period of 10 years. And suppose the first suit is foreclosure. If I could not pay the money to you within the period of 10 years or 1 year, stipulated period of time, you as a mortgagee have a right to foreclose the mortgage. Mean the mortgage khatam ho chuka hai, opportunity was given to you to pay the money back to me, I not been able to pay. So that is suit is called suit for foreclosure and sale of the property. That this honorable court be pleased to appoint a court receiver to dispose of the property by public auction or by private treaty. That is your prayer. This is also suit is covered under Order 34 of the Code of Civil Procedure. Order 34 के अंदर cover हुआ है suit. Yeah, what happened? Yeah, Order 34 में cover हुआ है. Second nature of suit which is covered under section 3. Yeah, anybody is asking any question? No, आप continue कीजिए. Yeah, the suit for closure के बाद sale, then the suit for redemption of a mortgage. Now redemption of a mortgage means the property which I mortgage with A, mortgage the property with B for a period of 5 years and took a loan of 1 crore. Now A says, return my property, my money is ready with interest, I am giving it back to you. Now the property का value बढ़ गया, city of Mumbai, Calcutta, Madras, wherever it is. B की नियत खराब हो गई, isn't it? He will say, I will not give you property. You give me market rate compensation or he was putting terms and condition. In such a situation, the mortgager, the original owner of the property, has a right to file a suit called suit for redemption of the mortgage. This is covered under the provisions of Order 34. Ab dekhiye, redemption, redeem the mortgage. You take back the money, I am prepared to deposit the mortgage money and please return back the money. The immovable property which was kept with you is a mortgage fulfilled, terms and condition, money is ready. So the mortgagee cannot resile from the contract, resile say that I'm not giving you. So under the Limitation Act, all of you know that mortgage suits can be filed within a period of 30 years. So please note that. Normally, most of the civil suits for recovery of property 12 years, mortgage के लिए special concession दिया गया है because historic reasons. That is 30 years. Now the third nature of the suit is or a charge upon immovable property. What is this? Or a charge upon immovable property.
Recording in progress.
Keep on aeroplane mode. Charge upon immovable property. Say I'm in lecture. Now, what is a charge? You have to go to section 100 of the Transfer of Property Act. Section 100 में charge is defined.
Can we wait for a minute?
Yes. Any problem?
I don't know why is there doesn't.
Section 16C, we learned the foreclosure suit, sale, redemption of the mortgage, and the last is creation of a charge of the immovable property. The creation of a charge is another is a ground in respect of a immovable property. Now, what is a charge? Charge is created under Section 100 of the Transfer of Property Act. When you are drafting a suit, a plain for recovery of immovable property by virtue of a mortgages, please bear in mind Section 100, how the charge is created. So not only that this Honorable Court be pleased to redeem the mortgage or foreclose the mortgage, that this Honorable Court be pleased to create a charge upon the immovable property so as to meet the requirement of the plaintiff in the matter. So that is the nature. Now Section 16D speaks of for determination of any other right or interest to immovable property. The Code of Civil Procedure contemplates here under Section 16 any other suit for determination of the right title interest. Now, determination of a right title interest, such a suit is filed under Section 34 of the Specific Relief Act. You seek a declaration that this Honorable Court be pleased to decide the character. It may be a suit for declaration that the defendant is a rank trespasser. It may be a suit for declaration that the plaintiff is in adverse possession. A suit under Article 64 and 65 of the Limitation Act. Such a suit should be filed within 12 years. Suppose the owner has filed a suit against you on the ground that you are a rank trespasser after a 12 years period. Under Article 27 of the Limitation Act, suit for recovery of the immovable property should be against the trespasser should be filed within 12 years. Aapka suit file ho gaya within 15-16 years. The defendant can raise a counterclaim. That the defendant has acquired a right by prescription. That this Honorable Court be pleased to declare that the defendant has acquired the status of adverse possession that will be sought under Section 34 of the Specific Relief Act, read with Article 65 of the Limitation Act. Please note that here. Then the last suit which is contemplated is second last E, for compensation for wrong to immovable property. Compensation for wrong to immovable property. Now you go and occupy a hotel in maybe Mahabaleshwar, maybe Alibag, you go and enjoy, you damage the property. The owner of the hotel can file a suit against you either in Alibag or wherever the hotel is situated or wherever you are residing. That is the under Section 13, it was damage to immovable property. Then last is F, for recovery of movable property actually under distraint or attachment. Now, recovery of movable properties are also covered under Section 5 and 7 of the Specific Relief Act. Similarly, immovable properties are also covered under the Specific Relief Act, Section 6 and 10 and 22. You know, though you are a student of second year law, you must have studied Specific Relief Act. Those provisions, you must know that. So the Specific Relief Act dealing with not only recovery of movable property, also immovable property. If you have been dispossessed without due process of law, you file a suit without title under Section 6, you should be restored back. You should be reinstated. And if you are filing a suit on title, that should be filed within 12 years under Section 6 of Clause 2 of the Act. If you are filing a suit for partition or a specific performance of a contract, that is a suit filed under Section 10 of the Specific Relief Act. A suit for partition family matter, Section 22 of the Specific Relief Act. So these are the various nature of suits under the other legislation. Now, apart from this, this is the CPC. Then other suits which are covered, Section 16 ka dekhe humne. Then I will also summarize the other suits which are covered by the CPC. Yes, yeah. Then yeah. Then if you see, you will learn. Then some of the suits I would like to give you the example. Partition suit dekh liya aapne. Then section 91 and 92 of the Code of Civil Procedure. They deal with suits, the suit relating to public charities and nuisance, isn't it? Please note that here. The Advocate General is involved. Normally, a suit against trust properties, particular, say for example, a particular trustee of the famous temple in Mumbai, they are misappropriating funds. You may go to the High Court and file a suit. In the city of Bombay, it is the High Court, District Court. You have to go file a suit for a declaration that the trustees are misappropriating the amount. That this honorable court be pleased to remove the trustees and appoint new trustees. That is a Section 91 suit. 92 suits are public charity suits here. That is there are the suits here. Then you have suits under the provisions of order the order 30 yeah, usse pehle dekha tha main suit. Then suits yes, suits under the provisions of suits against the government. Suits against the government, that is Section 80, Section 80, 81, 82 and Order 27. How the suits are filed against government? You are required to give 2 months prior notice to the government authorities. Why? The reason you are required to give notice, the time of the public money is not wasted. And in case the government doesn't chooses to, normally would like to pay their money, but if they don't pay the money, there should not be unnecessary litigation. At the notice stage itself, they might pay. So the law mandates that here that suit can be filed, can only be filed after giving 2 months notice minimum. That is a Section 80, Section 79 to 82 and Order 27 of the CPC. Then you have suits. Then you have suits against the corporation under Order 29. How the suits are filed against a company, isn't it? A company limited under the provisions of Companies Act. Then what are the requirements? Then you are required to file a suit against a registered company, giving a notice to them. But fortunately, Section 20 of the Act said that if the company has got several branches, like McDonald's has a branches in all throughout India, all throughout the world, maybe registered company, maybe in USA, but you can file a suit anywhere for claiming damages. For if they owe you money, you need not go to USA. So Section 20 clearly says that any of the offices can be filed here. 29. Then there are suits under the provisions of Order 32. There are suits against minors and unsound person. That you know that here, how the suits are filed against minors, and you require a next friend. The next friend, a minor cannot contract. Next friend is required. Somebody, a brother, sister, uncle, is nobody. The court will appoint somebody. A guardian, if it's defendant, a guardian ad litem will be appointed. So the guardian ad litem, a next friend, will make a statement in the plain and the written statement that they do not have any interest against the minor. Okay, that is important. Then you have important suits under the provisions of CPC, interpleader suit. नाम तो सुने होंगे आप. This is covered under section 88 and order 35 of the CPC. Interpleader suit is a suit where the plaintiff doesn't have interest. The plaintiff is only interested in who is the real owner of the property. Suppose the landlord dies, you are a tenant, 10 people are giving notice, you give us rent. You cannot give rent to 10 people. You have a right to file an interpleader suit to determine who the real landlord is, who the real owner is. Similarly, under the provisions of the Indian Contract Act, you have learned a provision called finder of a good, isn't it? A finder of a good, that is, you'll find under section 71 of the Indian Contract Act. So if I find your diamond ring and I want to return to you, your brother, sister, everybody will demand ke hamara property, meri property, a neighbor. Are you found in a college? Every student says it is mine. Then you have a right to file a suit called the suit in the nature of an interpleader suit from the court of law to decide who the real owner is. You are only interested in the cost of the suit and not in the subject matter of the suit. That is the interpleader suit. Then the provisions of 33 of the CPC deals with the suits by indigent person. So on account of poverty of a person cannot be deprived of filing a suit. He has a right to file a suit. You can make a statement before the court that at the moment I'm an indigent person, a poor person below poverty line. I do not have the court fees to pay. In a city of Mumbai, Maharashtra, the maximum court fees is 3 lakh rupees. You do not have the court fees to pay. Your property may be running into crores. XYZ has trespassed into it. You are seeking eviction order. So you can seek an order. You can make an application to the court that you may be permitted to sue as an indigent person under the provisions of Order 33 of the Code of Civil Procedure. Then we learn suit of nuisance, so we learn under section 91. Wherever there is a public nuisance, under section 91 of the Code of Civil Procedure, you can file it here. Then the CPC also deals with the suits by aliens, aliens or against rulers, ambassadors, envoys. That is section 83 of the Code of Civil Procedure deals with situation, isn't it? 87B आप चेक करेंगे यहाँ पे मालूम पड़ेगा उसके अंदर. So you require the permission of the central government against aliens to file a suit, isn't it? And if you let out your property to suppose American embassy, such a suit, you have to give certain notice. In some cases, you require the if it is a suit between landlord and tenant, you don't require permission. If it is a suit, if they are trespass upon your property, you require the sanction, permission of the central government of India. That is the provision. You should know that here. Then there are suits. You can also file a suit under 27A CPC, suits involving substantial question of law as to interpretation of the Indian Constitution, validity of the statutory investment. So it is not only writ petitions are filed under Article 32 in the Supreme Court or 226 in the High Court. Even a civil suit can be filed under Order 27A CPC, challenging the constitutional validity of a particular provision. In a civil suit, you can file it before the civil court. Somebody has filed a suit against you that you are a trespasser, vacated. You may challenge the provision. So-and-so provision is void. So-and-so provision is declared illegal. So-and-so provision is against the spirit of Article 308 of the Constitution. So the civil court can also decide such suits by giving a notice to the Advocate General in the matter for assisting the court. Then we have also covered suit under Order 28, suits by or against military or naval or army man. So these are the special category of person. They need not, but they may be on a duty, performing duty for the country at the border. They cannot personally come and file a suit. They may appoint somebody, some authorized person to file a suit. That procedure is given over there. Then Order Order 30 speaks of suits against partnership firms. How partnership firm, the partnership firm can be sued. But if the court insists that you must join the partners, you have to join. But there is no mandatory requirement the partner should be joined in the matter, isn't it? But in a suit for dissolution of a partnership firm, then it is necessary to add the partners. Who are the partners who at the time of the registration of the firm? That is covered under Order 30 of the Code of Civil. 31 speaks of suits against trustees, executors, and administrators. So it may be a trust, a public trust under the Bombay Public Trust Act, or under the Private Trust Act of 1882. There's a family trust created. How the suits are filed is covered under the provisions of Order 31 of the Code of Civil Procedure. In that, even you must join all the trustees. In a suit against trustees, the mandatory requirement is just on all the trustees. You just cannot just join the trust. That is the mandatory requirement that tells you. Then 33A, suit relating to matters concerning family. 33A, that is a family matters. That is a suit. For earlier, there was no family court. There was no family court. Suit for divorce used to be filed in the Bombay High Court between the couples who are under the Indian Christian Act, Muslim Marriages Act, and in the City Civil Code under the Hama Act, under the Hindu Marriage Act. And still in the Bombay High Court, suits arising for the divorce between the Parsi couples are being filed in the High Court. There they have delegate system. Now, the provisions of CPC or 32A become redundant because the family court has been set up. Under the provisions of Section 7 of the Family Court Act, majority of the family court suits go to the family court in Bombay. If there is no family court in any of the areas, then the matter will go to the civil judge senior division, or they go to the district court, wherever the authority is given. So these are then there is one more suit I would like to discuss under the CPC, is a representative suit. Under Order 1, Rule 8 CPC, it's like a public interest litigation. In the year 1908, it started. Whereas public interest litigation under Article 226 started recently in the year 80s and in 80, 82, 83, where Justice Bhagwati started this concept. But whereas in CPC, the concept of filing a public interest litigation has been there from time immemorial. When two or more person can file a suit in a representative capacity. Suppose, for example, the municipal corporation MAHADA has given a notice for eviction against the occupants at Dharavi. There may be 10,000 occupants. Similar notice for eviction is given. Demolition notice is given. Under the BMC Act 351 notice diya gaya. Khali karo ya todo. Then one person can sue for himself on behalf of everybody. That is called a representative suit. In a city civil code, if you go on, these are suits called LE suits. They are called they are long cause suit, LC suits. LC long cause suits joining the municipal corporation. Giving of a notice becomes necessary before filing a suit against municipal corporation, but in cases of emergency, you can make a prayer that the notice giving be dispensed with, because they are demolishing the property within a period of 7 days. Whereas the law demands that public notice to be given within 1 month's time or 2 months' time, which cannot be complied with. Highly impossible. By virtue of the notice given under 351, they are deemed to have given up or waived their legal rights. So such a suit in the nature of a LC suit can be filed in the City Civil Court, Bombay, for a declaration that the notice which has been issued by the corporation under 351 be declared illegal. That this honorable court be pleased to grant a perpetual order of injunction restraining the corporation from giving effect to the notice. That kind of declaration you can obtain under Section 37, 38 of the Specific Relief Act, which provides for mandatory orders and perpetual order of injunction. These suits can be filed here. So, in a representative capacity, you can file it. One person can sue for himself on behalf of other. Only the law mandate that you need to obtain the leave of the court. Order 1, Rule 10, Subclause 2 say that leave of the court to be taken. Normally, the leave is granted by the court as a matter of course. Court will say that you saw those people or give a publication in the newspaper. But if you have already added, everybody has signed the Wakalatnama, given the name to you, and you might say that tell the court, the publication in the newspaper be dispensed with unnecessary. That can be done. So these are the nature of the suits under the Code of Civil Procedure. If anybody want to ask me question, then I will take some of the suits under the other provisions like Trademark Act, under the provisions of Copyright Act, the other suits here. The take for example under the Trademark Act, the suits for infringement, copyright, they are filed under section 134 before and 135 of the Trademark Act in the district court in the city of Bombay, in the Bombay High Court original site. Please note that here. Similarly, suits under the provisions of copyright infringement, such a suit will be filed under the provisions of section 105, the again district court, Bombay High Court. There is a Patent Act also. Under the provisions of the Patent Act, the suit would lie in the High Court in Bombay. These are special acts, isn't it? Yeah, these are the various civil suits. Then CPC also speaks about venue administration suit. Order 20, Rule 13 CPC speaks of administration suit. Then there's a suit also called preemption suit. When you see Order 20, Rule 14 speaks of preemption suit. A preemption suit mean plaintiff should be given a preference of buying the property which is sought to be sold by your neighbor. Such provisions you will find under section 22 of the Hindu Succession Act. The heirs of the deceased, your grandfather, father left behind property, you are a class 1 heir along with your mother or a brother, they cannot sell your shares without your consent and permission. You have a preferential right of purchasing it. That is called a preemption suit. That is also contained under section 44 of the Transfer of Property Act. Joint family dwelling house cannot be sold to strangers. It should be sold, preference should be given to family house. So even in the Mohammedan law, it's a customary law which contains a provision called shufa, SHUFFA, shufa, which means the neighbor or family member has got the preferential right to file a suit for preemption and not the strangers. Okay, these are the various suits. If anybody has any question, please ask me. Hopefully it is clear to you all. There are participants.
Yes. I guess they don't have any questions.
So you don't get confused. There are so many suits. Hundreds of suits. And suits between a member and society in a cooperative society go to the cooperative code under section 91.
Substantial question of law.
Substantial question of law relating to the constitution, interpretation of the institution, or any lack. You may say that under section 23 of the Indian Contract Act, the contract is sham, colorable, and bogus. You may want to challenge a particular provision of the Arbitration Act. You have a right to file a suit that this honorable court be pleased to declare that this provision is unjust, contrary to the law. So there is no bar in filing a suit, civil suit. You can file a suit, and under the provisions of Order 27A, the court can entertain such a civil suit. Substantial question of law. और कुछ है? But the Advocate General has to be heard in this matter. Without being heard, the court cannot pass the order. or it is possible the High Court may transfer the case. और कुछ है?
नहीं,
I think we have fairly covered almost every suits.
Sir, I have a doubt.
हाँ बोलिए.
Sir, like you gave the example where the tenants are confused as to whom should they pay the rent to when there are many claimants.
Yes.
So the interpleader suit will be filed.
Yes.
Sir, I have a doubt regarding that. Like under Order 35,
Yes.
under Rule 5,
Hmm.
Rule 5 is precluding tenants from filing a suit against their principals.
Yes. Show me that. Yeah, CPC खोलो. But tenants are not claiming any interest. Only for declaration as to who is the owner. They are not claiming any rights. Read that provision, Order 35, Rule 5.
Agents and tenants may not institute interpleader suits.
Hmm.
Nothing in this order shall be deemed to enable agents to sue their principals or tenants to sue their landlords for the purpose of compelling them
The
to.
landlord is dead and gone. You are not filing against a landlord. There is a estoppel against you from the suing. You are filing a suit against strangers.
Right, sir.
Against landlord you cannot file a suit. There is estoppel under the provisions of 115(16) of the Evidence Act.
Evidence Act, yes.
वहां पे क्या नहीं कर सकते. But you are filing a suit against strangers with
Right, sir.
whom you have no contractual relationship of landlord and tenant.
Correct, sir.
समझे ना आप? So
Got it.
if you know somebody is your landlord, you cannot file a suit. You are bound to pay him rent. But उनके मरने के बाद somebody XYZ third person says, I am the owner, I am the heir, I am the successor. But they are not showing you any proof. They don't have any credentials. Then you have a right to ask them, in what capacity I must pay you? You please prove your bona fides. If they don't show the bona fides, you have a right to say that a interpleader suit can be filed to determine your status and whom should I pay. You are not seeking any relief for yourself. You
Got
are
it,
not
sir.
filing a suit against your owner. Please note that. You are filing a suit against third person who has not established his ownership.
Okay, sir. Thank you.
Okay. और कुछ पूछना है?
There's the Bali asking, good evening, sir. If I have to explain, express, and implied bar to jurisdiction section 9, what are the relevant provisions with the help of which I can explain?
Yes. If I had to express an implied bar, express mean where the legislation is very clear. Like for example, the provisions of section 91 clearly state that all suits between member and society as regards all question touching the society business should be filed in a cooperative societies court. That is called express legislation. Similarly, section 33 of the Maharashtra Rent Control Act says that all suits between landlord and tenant should be filed in the court of small causes court and nowhere else. That is called express bar. Implied bar mean where it is indirectly stated that you cannot go there. For example, law may not be clear. Law may not be clear as to where your rights are, whether a civil court you have to go or you have to go to a tribunal. For claiming damages, can an employee go against his management to the labor court, which is a tribunal, or he has to go to a civil court? So, by virtue of section 9, there is an implied bar. He cannot go to court. He has to go to tribunal only. But the tribunal is silent about the compensation part. The tribunal says that here the reinstatement with back wages. You may be claiming the trustee may have been dispossessed. He has lost his trusteeship. Now, there is no express provision in the law as to which court you should go to. When there is no express bar, you can come to civil court. Now, revenue authorities, for your entries, your revenue authorities can entertain certain application or certain proceeding for rectification of your property errors. But they have no right to challenge. You cannot go and challenge your title before the revenue authority tribunal. There is no express bar. Then you can come to the civil court. Under the Maharashtra Land Revenue Code, all matters relating to your land should be gone to the tribunal. The tribunal will decide it. But if there is an express bar, if there is an implied bar, if there is no prohibition, you can come to civil court. If there is a specific prohibition, you cannot come to the civil court. Like husband and wife fighting over property. Now, Section 7 of the Family Court Act says that all disputes between husband and wife to be tried in the family court. But if a declaration is sought that the husband will take up the plea, or husband and wife, the property has been purchased from my funds and his name is appearing as a Benamidar. A Benamidar. So, in such a scenario, so there is no specific bar under the Family Court Act that you cannot go to the civil court. Or the court may say that there is an implied bar. All suits and proceedings between husband and wife should be tried by the family court. Yeah.
Concerning the family court.
Yes. That is also covered under Order 32A of the CPC. 32A CPC is applicable nowadays wherever there is no family court. If there is a family court, you have to go to family court under Section 7. Otherwise, there is no bar in the civil court in entertaining petition for divorce, guardianship, where there is no family.
Someone is asking CPC section 16A and B.
Ah.
What are the suit types?
16A
And B.
16A में cover किया ना अभी मैं?
हाँ, someone is asking.
Yeah. Section 16A.
Praveen is asking.
Suit for recovery of immovable property with or without rent or profits.
And B also.
I gave you examples here. If you are filing a suit against a trespasser, for declaration that trespasser, you can file a suit for eviction and claim mean profit. If you are filing a suit against a tenant for eviction, recovery of rent as well as mean profits, mean profit become payable after determination of tenancy. If the suit for trespass will go to City Civil High Court depending upon the valuation, suit against tenants and licensees, they go to the Court of Small Causes Court under Section 33 of the Maharashtra Rent Control Act, if it is Rent Act matter, if it is a Transfer of Property Act matter, Section 41 of the Presidency. Section the B partition suits, they will go to civil court under Section 9. 16A can come both in that Section 9, barring Rent Act matters. Section 16B, partition suit only go to civil court under Section 9 because there is a bar under Section 19 of the Presidency Small Cause Court Act. Check karo aap. Small Causes Court cannot try partition suit. Small Causes Court cannot try title suit. Small Causes Court cannot try suit for specific performance. Mortgage suits. Section 19 padhiya. There is a specific bar. Yeah. Anything else?
No.
Hopefully everything is clear.
Sir, one more doubt I have.
हाँ बोलिए.
Sir, like when the properties are scattered like across India,
Hmm.
and someone wants to file a administration suit.
Yes,
So you said that under clause 12 of letters patent, he will have to obtain the leave.
leave of the court.
Yes, sir. But sir, in other areas where the letters patent is not,
Section
uh,
20, Section 20 पढ़िए CPC. Section 20 में you can take leave.
Other suits to be instituted if under the side or cause of action arise.
Section 20 clause B speaks of a leave of the court.
right, sir.
Okay.
Okay, sir.
Okay. Anything else? Shall we wind up now for the day? Next week's Saturday, we'll take some lecture on BNSS CRPC, criminal law. That is remand, bail bail to magistrate, bail before the police officers, bail before the court of session, bail before the high court, and anticipatory bail provision. Okay. Okay. Good night, all of you.
Listen, thank you.
Hmm?
Listen, thank you.
Disconnected. Thank you. Thank you so much. Welcome. Welcome.